I did not threaten my daughter.
Sir, what did your attorney just say? You're going to have a rough road if you don't listen to your attorney.
I apologize.
Court calls case People versus Yashir Paris.
Good morning.
Good morning. Your name?
Yasser Ferris.
Yes, sir. Sir, you are before the court on a complaint that alleges that on January 27, 2024, at the location of 3949 Oak Drive in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of child abuse in the fourth degree. You understand the nature of that charge, sir?
I understand, Your Honor.
That is a misdemeanor punishable by up to 1 year or probation up to 5 years. You understand that, sir?
I understand that.
First question I have for you is, do you want to be represented by counsel?
I don't know if that will be necessary or no, because I don't know what's going on.
You don't know what?
I don't know what's going on.
What do you mean you don't know what's going on?
I mean, I got this letter after my daughter, 16 years old, was tried to manipulate.
Hold it, sir. First thing I'll say to you is that anything that you say can and will be used against you or can be used against you. You understand that? So I really don't want you talking about what may be the alleged offense.
Okay.
All right. Specifically, so that we're all clear, the complaint alleges that on the date I had mentioned and at the location that you did knowingly or intentionally commit the following acts or acts under circumstances that posed an unreasonable risk of harm or physical injury to a child by shoving the child or grabbing the child by the hair, contrary to Michigan statutes. So you understand the specifics of what's being alleged at this time.
Yeah, when I read it, I understand it. Yes, Your Honor.
Pardon?
When I read it, I understand it, but I did not shove my daughter.
Well, hold on, sir. Again, I don't want you saying that. My question to you is, do you wish to be represented by an attorney?
I don't know. Yes.
This is a public defender case. Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Defendant's behalf. I'll adjourn this matter to May 1st, 2024, 9 a.m. or as indicated. As the bond in this case, I'm going to indicate $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of weapons. You understand that, sir?
Yes, Your Honor.
Only because of something that you said. My understanding is this involves, I'll say, a teenage daughter. Is that correct?
Yes, Your Honor.
Understanding. All right. Are you still residing in that? Is she residing in the same premises as you?
Yes, I still take care of her. I still drive her to school daily and pick her up.
So people have a position regarding bond and contact. Let me just do this before you answer that. I'll order no alcohol, no recreational marijuana, or any illegal drugs.
No, Your Honor.
All right.
Yes, Your Honor, we are requesting no contact.
Okay. Sir, you don't have a position because you haven't talked to him yet.
Yeah, I mean, based on his statements, it seems like he drives her to the school, so we can.
Let me do this so that you can get the information. Let me pass this matter. Let you guys talk to him before I set bond conditions on it. Okay, so that I get a full picture. I'll call you back up, probably my next block, so we can get that bond conditions.
Do you want me to wait, stay open?
Well, you can wait back there and they're going to want to talk to you before I do that, so I can get all the information. Court calls case People versus Yashir Paris. Recall.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Mr. Cashier, who is approaching. State your name for the record.
Yes, sir. Kazal Ferris.
All right. We were addressing the issue of the no contact.
Your, we would be asking that you be allowed to have contact while this case is pending with maybe a condition of no corporal punishment They do live with, together inside an intake household with the mother. Mother is blind though. He does all of the driving, the cooking in the household. He also works full-time, and drives the daughter, inside this case, who's a complainant witness, to school daily, to therapy and doctor's appointments.
Is it just the three of you?
It's 5 total.
Five
There's 2
total.
other sons. The sons are 14 and 8 years old.
So they're younger than the other. Got it.
Yes, Your Honor.
Okay.
Your Honor, I have to say I'm concerned in this case. He shoved his daughter, grabbed her by the hair, threw a bone at her, and he threatened to stab her in the throat if she called the police. I'm extremely concerned based off of the nature of the allegations, and I understand there's complex situations within the family home, but
Well, but if I say no contact, the problem is that then he's gonna have to leave the home, right? If he leaves the home, then his wife, who is visually impaired, has to try to function with a 16, 14, and 8-year-old, none of them who drive, I take it.
Correct, Your Honor.
So I don't even know how that would work.
can we at least have part of the bond conditions that he is not to discuss the case in any matter whatsoever with the rest of the family in the home?
I have no objection.
You understand that, sir?
No,
You don't understand what was just said.
I don't understand what the request was.
The request is that you not discuss the case with anybody else in the home.
Yes, now I understand.
That's the condition that I'll put in place. I will also,
Can I say something, Your Honor?
That's about the case. I do not recommend it because anything you say can will be used.
I understand. I did not threaten my daughter.
sir, what did your attorney just say? You're gonna have a rough road if you don't listen to your attorney.
I apologize.
So I'm ordering 2 things. Not to discuss the case with anyone in the household, and there's no use of any physical discipline on any of the children. Thank you.
Thank you.
Court calls the case of the people versus Raphael Grabowski.
David Eichel, appearing on behalf of the defendant, probably the only person here this morning who's been here more than Joe Simon.
That's probably, that's probably true.
That's only because I'm older,
I don't know. I think you're younger than Joe, at least in spirit. Anyway,
Your Honor, we're reached an agreement in this matter. Ms. Barroso is going to add a second count of driving while visibly impaired, second offense. My client will tender a plea to that charge, and the original charge will be dismissed.
That is correct, Your Honor.
the 1 year.
Correct.
May I have him sworn?
Raise your right hand. You swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Raphael James Grabowski.
All right, sir, it is this court's understanding you're going to plead guilty to an added count 2 of operating while visibly impaired, second offense. That is a misdemeanor punishable by up to 1 year incarceration to a $1,000 fine plus court costs. The court could order community service or rehabilitative services as the court deemed necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
I do, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty. Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. Had you signed any advice or rights form?
He may not have had,
Oh, okay.
we may,
Because you're not, he'll have to sign one.
we may have,
Because you're not having a trial, you're giving up rights. You're giving up your right to call witnesses to speak for your trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your
Are you on probation or parole?
Honor. No, Your Honor.
Does anybody, go ahead. Anybody promise you anything to get you to plead guilty other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Uh,
of your own free will
yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your
On the date of March 26, 2023, Ellsworth Road near Research Drive in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor? Do you recall what you had and how much?
I had two-hearted ales, and three and a half.
Were you stopped by the police or was there an accident?
I was stopped by the police
Why'd they stop you?
for speeding.
All right, were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital or police station?
First police station, then the hospital.
All right, was there a blood draw?
Uh,
Was the result a 0.120?
Yes, Your Honor.
All right. As well as there was marijuana in your system? Is that correct?
Yes, Your Honor.
All right. You have any reason to dispute those blood test results?
No, sir.
Taking everything into consideration on that date and at that time, do you believe your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. And had you previously, I can find it here. Had you previously been convicted of operating while intoxicated on or about March 26, 2019 in Perrysburg?
It was sometime that year, but yes, I was convicted on,
But, pardon?
it was, I can't remember the month, but yes, I was convicted. I think it was April.
You were convicted, okay. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea to count two, count one is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
May 22nd at 9 a.m.
May 22nd, 2024, 9 a.m.
I think I just said something in another court that morning, Your Honor. And down in, well, you know what? It's in Detroit, but I can get back here before noon if that's okay.
Yeah, that'd be fine. Actually, just have your office send a message to Ann and we'll try to put you in a block that's later.
Okay.
All right, it's fine. Okay, thank you.
Your Honor, there is one other thing I'd like to address. If the court recalls, last time we were here,
Oh, yeah, I recall.
Mr. Grabowski,
I absolutely recall.
Mr. Grabowski pled guilty to a violation and that he consumed alcohol while on bond and while on the Silver Lake.
Yeah, the brushing of the teeth and the
Yep.
other thing. Yeah, I remember.
Your Honor, what he's asking the court to do is you put him on a scram tether.
Correct.
He's asking if he can go back to the Silver Lake. The reason being, he does heavy construction. You can see he came from work today, you can see. And having that tether makes it difficult for him to get in and out of tight places while he's working. Obviously, the Sober Link worked because you were able to see that he had violated, and that was the basis of the violation. So he was using the Sober Link, and the Sober Link was functioning properly. So we're asking to let him off completely. We're just asking before we go back to the Sober Link.
Well, and let's be clear with this, because it was that, and then it was also the lying to me.
I
And
understand.
that is a problem for me.
I understand.
Why I'm doing this, but I'll do it. But it's testing. We'll need to send over an amended order. He tests 4 times per day. And sir, I'm just giving you this admonition that if it comes back positive, don't ask anything.
I understand that.
I was hesitant to even ask to go back to the Sober Link, Your Honor.
Oh, I know you were, and you probably didn't expect me to even get that response, but I'll let it happen.
Okay.
But if you mess it up, yeah.
I know, I got a lot to lose.
Court calls the case, People versus James Kloss.
And Your Honor, I've spoken to the prosecutor briefly prior to today, but I'd like an opportunity to speak to her this morning. I believe we have a plea agreement.
What?
We spoke, Your Honor.
Okay, so what are we doing?
Your Honor, the defendant, who's 76 years old and has no prior criminal record, he's charged with retail fraud. He made a mistake at a Meijer checkout. He is pleading guilty with the hope that the court will take his sentence under advisement for a period of time.
Under prosecutor's deferred, Your Honor.
So you're doing a prosecutor's deferred.
Yes, and I do want to note for the record, there is no restitution at issue.
Got it. So he's pleading guilty. All right. May I have, all right, may I have him sworn?
Raise your right hand. Do you swear and affirm the testimony?
Yes, I do.
State your name.
James Koss.
Is he signed an advice of rights form, sir?
He did in my office and I mailed it in. I want to make sure it's in the court file.
Okay, he did in your office, but
And I mailed it to the court, but
yeah, I don't have it. He can just sign another one.
we'll sign another one, Your Honor. And I'll mention to the court, the gentleman is 76 years old, soon to be 77. Unfortunately, very hard of hearing.
Oh, is he? We have equipment we can give him.
Yeah, I think he's your face, right? We went over.
It's funny.
Yeah.
Sir, it's this court's understanding that you're going to be pleading guilty to the charge of retail fraud second degree. Is that correct? All right, that is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the fine. You understand that, sir?
Yes,
All right,
He does, Your Honor.
all right. Understanding all of that, do you still wish to plead guilty?
yes,
Yes.
yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form. Do you have any questions regarding any of those rights?
no, I don't.
All right, you'll see on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On October 26, 2023, at the location of 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Meyer store that makes you think that you're guilty?
I took stuff I didn't scan through and walked out.
Okay, so you skip scanned certain items and tried to walk out of the store?
That's correct.
All right. The store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to do that, did you?
No, sir.
And these items that you skip scanned, these were items that were offered for sale by Meyer?
Yes, sir.
All right, and this is on value. The total amount or the aggregate amount of the items that you scanned, was that in excess of $200, the value?
It was 265, I believe.
Okay, so that'd do it. Okay, no, that's fine. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied, thank you.
The defendant is satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation court and consideration of prosecutors deferred. Sentencing in this matter will be May 22nd, 2024, 9 a.m.
It's fine, Your Honor. Thank you, Your Honor.
All right, thank you,
Thank you.
bond. Thank you, Your Honor.
Thank you.
On behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Schlicht in both matters. Go ahead and state your name, Chase. Chase Schlicht.
Thank you.
We've reached a resolution, Your Honor, I think in both matters.
Okay.
Your Honor, it's my understanding, the defendant is going to enter a plea in the state case. And if he does that, I think it's operating with visibly impaired. In the state case, the township matter would be dismissed.
That is correct. The offer is to plead to an added count 2 of operating while visually impaired, and the exchange count 1 would be dismissed.
That's our understanding, Your Honor. I went over his advice of rights with him fresh this morning. He's ready to enter his plea.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Chase Schlicht.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days jail, up to a $300 fine plus court costs. Court could also order community service and any rehabilitative services the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct? Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything to get you to plead guilty other than what's been stated here today on the record? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yeah.
Of your own free will?
Yes.
Because you believe that you're guilty?
Yes, Your Honor.
February 10th, 2024, at the location of Oak Valley Waters Road near Oak Valley Drive, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor? What'd you have? How much?
I had a few hearteds throughout the night after my accident. It's kind of hard to recall exactly how much. He only remembers what he started drinking. Your Honor.
Gotcha. And you had an accident?
Yep.
What do you recall what happened?
I fell asleep behind the wheel and I was in a single car collision, or it was just me involved, but I hit a street light.
A pole, a utility.
Yeah.
Emergency vehicles, including the police, arrived and you were taken to the hospital. Is that correct?
I was first taken to Pittsfield PD and then after taken to the hospital.
All right. Was there a blood draw?
Yes.
All right. What were the results of that blood draw?
0.149.
Is that correct?
Yes, Your Honor.
Do you have any reason to dispute those blood test results, sir?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
Counsel, have I complied with?
The people are satisfied.
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed, as well as the ticket from Pittsfield. I think is a PBT refusal is also dismissed.
Your Honor, I just want to inform the court that my client screening assess, he's in now 5 sessions of the 12-week discovery program at Dawn Farm. He's now completed 5 of 12. He's being tested by ETG tests there weekly, but there's no community corrections referral at this time. I told my client the court might add that on.
Yes, and how often is he getting an ETG?
Is it once weekly? It's random at that, but I've had in 5 weeks, I've had 2.
All right. Defendants referred to Von Schwartz and alcohol screening assessment and victims impact panel. Sentencing in this matter will be May 22nd, 2024, 9 a.m. Defendant is referred to community corrections for placement on a sober link.
Oh, no, I'm sorry, I didn't get the date. I apologize. Sentencing date?
Which date?
What-
Sentencing? You said that so long ago. May 22nd.
Thank you. Oh,
Court recalls the case people versus Christopher Wentworth.
Prosecuting attorney Morgan Rose on behalf of people.
Good morning, Your Honor. Alexander Hermanowski with and on behalf of Christopher Wentworth.
This is a recall.
Yeah, I spoke.
Christopher Wentworth,
Yes, sir.
state your name.
Christopher Wentworth.
All right. Okay, find these here. What are we doing?
Your Honor, we have a resolution in this matter. A resolution is to plead to the retail fraud third with the prosecutors deferred.
That is correct, Your Honor. Additionally, there's no restitution at issue in this case.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Christopher Wentworth.
Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud in the 3rd degree. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right, if you still have your hand up, you can put that down, but, all right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce?
Nope.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
May 25th, 2023, at the location of 7000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan. What did you do at the Walmart store that makes you think that you're guilty?
Did not scan a few things in my cart and tried leaving the store.
All right, so you tried to skip scan items?
Yes.
Store was open to the public at the time?
Yes.
These items that you skip scanned, these were items that were offered for sale by Walmart?
Yes.
You didn't have anybody's permission to do that, did you?
No.
Counsel, have I complied with the court rule? Would it be proper to accept the defendant's plea?
The people are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report, and consideration of the prosecutor's deferred sentencing in this matter will be May 22nd, 2024, 9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Rab is signing in right now.
Right now.
Yeah, he's at the bottom of your screen.
Deputy Rab. Where did he go? Oh, there he is.
Yes, Your Honor, present.
All right. If you can please raise your right hand. I do have your warrant in front of me. Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of your knowledge, information, and belief?
I do.
And I get to wait for probation to call you.
I got his, I do. I don't know who else is talking. All right, I've signed off on this and we'll get this right back over to you. Okay? Thank you,
Thank you
sir.
for your time, Your
Stay
Honor.
safe, please. They're still not in the courtroom, so I'll call them up the first part of that other block, the next block.
Oh, that's
All right. Ms. Hamoud, welcome.
Good morning, sir. How are you?
So you walk in to great fanfare from everyone. Good morning. Yes, I see that. All right, court's going to stand in brief recess. Court calls the case of the People versus Anthony Lewis.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of the people.
Morning, Your Honor. Attorney John Freeman on behalf of Mr. Lewis, who appears via Zoom today.
All right. Mr. Lewis, can you state your name, please?
Anthony Lewis.
Thank you. Has not been arraigned. Do you, as to the arraignment, your client waives formal reading, stands mute?
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. All right. And what are we doing on this case today?
Your Honor, can we have a pretrial on May 8th?
Pardon?
May we have a pretrial date on May 8th?
Wow, they're picking their own date.
Sometime in May, Your Honor.
Okay, that'll work.
Not June.
I'll adjourn it to May 8th. How does that sound? Okay. All right, May 8th, 2024. That's the sentencing docket. I can't do that day.
I'm sorry, could you say that again, Your Honor?
I have May 1st or May, which one?
First or 15th.
1st or 15th?
Let's go for May 1st, please.
May 1st?
May 1. May we
I'll set it
do
for
this
May.
Can we do it via Zoom, Your Honor?
I will not have an objection to that for the first pretrial. May 1st, 2024, 9 a.m. I'll set defendant's bond, $5,000 personal recognizance bond, order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
As far as the weapons go, this is a hunting offense. My client's a lawful gun owner. He's charged with not having a plug in his shotgun while hunting waterfowl.
No, I see that. All right.
So to deny him the ability to have a firearm because he allegedly didn't have a plug in the gun, I'll just note for the record that the gun did not have more shells than is legally permitted. It's just that he didn't have the plug in the gun.
Anything from the people? It's my I'm going to tell you, counsel, it's my standard condition on any type of firearm offense, regardless, because I don't know all of the factual circumstances surrounding that. So I'll take a response to the people, but I'm going to order it at this time. There also is to be no possession of alcohol, recreational marijuana, or any illegal drug. I won't order any other standard. Those are just the standard conditions that I'll order. Thank you. We'll see you May 1st.
Good morning, Judge Patrick Nineheist, P76343. On behalf of Ms. Scott, would you say your name, Ms. Scott?
Here.
Thank you. All right, what are we doing?
Judge, at this time, we're going to accept the prosecution's offer to dismiss the original account and plead guilty to operating while visibly impaired.
That is correct.
And Ms. Scott has executed her advice of rights form and it's been provided to the court.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Here, Scott.
Ma'am, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. Court could also order any rehabilitative services or community service the court deems necessary. Court could order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights? Look at paragraph 5. You see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty? Anybody threaten you or coerce you? You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
All right. October 11th, 2023, at the location of Packard and Hawks, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I had 2 drinks of margaritas.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Pardon?
I was stopped by the police.
You were stopped?
Yes.
Were you stopped by the police or were you stopped on the road?
She was stopped by the police.
Stopped by the police.
All right. Why'd they stop you?
Because I was speeding. I had to go to the bathroom.
Okay. All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the police station?
Yes.
Were you given a data master test or
Oh,
or was there blood?
Judge, it was a blood draw because she's pre-diabetic, so they had to get a search warrant.
All right.
And we can stipulate that the blood was 0.176.
178.
Oh, sorry.
No,
My
you're just fine.
apologies.
Thank you.
You have any dispute regarding those blood test results?
no, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to consumption of alcohol?
Yes, Your Honor.
All right, counsel, have I complied with the court rule?
You have, Judge. Thank you.
The people are satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz. for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
Second, 9 a.m.
May 22nd, 2024, 9 a.m. Bond with the conditions will continue.
Thank you very much, Judge.
Thank you.
What time did you say on the 22nd?
9 a.m.
Thank you.
Or as your invite indicates. Court does call all of the cases of Kiwanis.
Assistant Prosecuting Attorney Morgan Barroso on behalf of people.
Conrad, someone on behalf of the township.
Janelle Hood on behalf of Kiwanis Thomas. In
Bridget.
cases ending in 1276, 1750, 0996, and 1186.
Bridget Cook on behalf of Ms. Thomas for all other cases.
All right.
We would like an adjournment. Your Honor, there's a
all of
lot of
these-
moving parts to this, and I think we want to make sure we do the best job we can for Ms. Thomas. Make sure we have all the information we need, and she has 2 PCCs scheduled for tomorrow that will likely be included in a resolution.
Or case.
There's more.
Okay. So how far out did you want an adjournment? Yes, I moved.
2 weeks, Judge.
When's your PCC?
Tomorrow.
These are all adjourned May 1st, 2024, 9 a.m.
Thank you, Judge.
Bond
And-
will continue in each of these cases.
Yes, Ms. Kiwanis wanted me to address bond for her, and I have a feeling what the court is likely to do, but just so that she is aware of what the court's position might be from the court itself. She was asking that she be released on some kind of either a PR bond or a lower cash bond. She missed court dates in the past because she was in the hospital. She indicated to me she was in the hospital for 7 weeks, was released and went back for 5 more weeks. She has a spinal disorder. She wants to resolve these cases and will come back to court if she is released.
Anything, Ms. Coons?
I would just like to add, whenever I did speak to her inside the jail yesterday, she did state to me that she was terminally ill and was given 6 months to a year to live. So we'd just be asking for her release.
What is her PCC on?
Drug possession, paraphernalia, and another felony drug possession, I believe that's the one you have.
Yes.
Yeah.
All right. Well, in these cases, I'm going to decline to change bond on those cases. I want to take a look at the whole picture, which includes their cases for tomorrow. So at this time, motion for bond reductions.
Thank you for hearing the motion.
Thank you. Calls case People versus Delgina Little.
Edward Drucas on behalf of Delgina Little.
Your name?
Delgina Little.
Thank you.
Your Honor, I believe we're close to a resolution. She does have a pending matter out of the 15th and out of Judge Slay. Has a pretrial and she's on probation up there. So I'm trying to work out a resolution that doesn't gonna have too big of an effect on her. So I'm asking for an adjournment. She's got some pretrials coming up. I was gonna ask for early May, but May 8th doesn't look good.
May 8th has the 1st or the 15th.
So I'd ask for the 15th.
During the matter, May 15th, 2024, 9 a.m. Bond will continue. Court calls the case People versus Kiara Scott. Kiara Scott,
But I don't know. Yeah.
was he physically here?
Yes, I saw him walk into the courtroom. My understanding is we were going to resolve it today. That was what he told me when he stopped by the table. So I don't think they ran off. He may just be talking.
I'll pass it. Court calls the case People versus Paul McGruffin. All right, thank you.
Mr. McGuffin is in Wayne County. He informed me yesterday, though, that he has an exam today scheduled in Dearborn Heights. So what I'm assuming is that they took him to Dearborn Heights and did not get him on Zoom here.
He has a preliminary exam,
Yes.
not a physical exam.
No.
Okay. All right.
Not at the doctor's.
Okay, all right, just checking. I'll adjourn it to May 1st. Why are you laughing? She just had an exam. I don't know what that was. All right. I'll adjourn it to May 1st.
Thank you.
Court calls the case, People versus Kevin Stevenson.
Prosecuting Attorney Gordon Barroso on behalf of the people.
Good morning, Your Honor. Alexander Hermanowski with and on behalf of Kevin Stevenson, who's approaching.
Your name, sir?
Kevin Stevens. How you doing, Judge?
I'm doing well. How you doing?
My.
All right. Okay.
Your Honor, this is a time and date set for pre-trial. This time we're asking that this matter be set for final settlement conference.
He held on anything else?
Yes, sir.
And we'd also like to adjust bond.
Jury final settlement conference will be June 7th, 2024 at 9 a.m. Jury selection, if necessary, will be June 10th, 2024, 8:30. Both of those proceedings are in person. Yes, Esteban.